you a chance to read that.
Yeah.
Well, it's a different view being up here. Before, I was on the wood table. Out there, I guess I'm not doing that.
Yeah, I asked Randy about this. We'd be on the side. Hey, okay.
Ladies and gentlemen, it's 1:30 and we're going to get started on the judiciary. This is the House Judiciary Committee. Representative Jim Hill is actually the chair. He's got a couple of bills in another committee that he's handling, and he'll be coming in here just in a little while. I do want to remind everybody to turn their phones down, but I also wanted to thank David Kimberly, who's filling in for Ray Hawthorne in helping us today since Ray's not available. Okay, very good. We've got the agenda in front of us. We're going to take one out of order. Representative Matt Simpson has HB 1, and then he has also HB 76. We're going to take those two first. And we're going to call the roll now.
Hill, Wadsworth.
Here.
England.
Here.
Almond.
Here.
Bedsole.
Here.
Chestnut. Faulkner.
Here.
McClammy. Here. Pettis.
Here.
Robbins.
Here.
Simpson.
Here.
Standridge. Starnes.
Here.
Stringer.
Here.
Tillman.
Here.
We have a
Okay. The first bill on the agenda is HB 1 by Representative Matt Simpson. Would you explain your bill?
Absolutely. Thank you, Mr. Chairman and members of the committee. What this bill will do is add mandatory minimum sentences for those convicted of trafficking fentanyl. And I want to make sure a couple of things are clear. This is single component pure fentanyl that we are discussing. This is not the mixture. The mixture is handed in another section of this similar code, of the same code. If you'll look on page 5 of the bill, specifically lines 122 and 123, there are already punishments in places for mixtures of fentanyl and other drugs and other issues, mixture of fentanyl and cocaine, mixed fentanyl and heroin, fentanyl and marijuana. There's already a punishment in place for fentanyl mixtures. This is for pure fentanyl. And what this will do, what this bill will do, is if you have between 1 gram and 2 grams, more than 1, but less than 2, it will be a mandatory minimum sentence of 3 calendar years. If you have between 2 and 4 grams, it'll be a mandatory minimum sentence of 10 calendar years. If you have between 4 grams and 8 grams, it'll be a mandatory minimum sentence of 25 calendar years. And if you have more than 8 grams, it's a mandatory life in prison. I have this packet here. It's a sweet and low that you would find at any diner that you guys would go to. This is 1 gram. If this 1 gram was pure fentanyl, it could kill every member of the House of Representatives 5 times over. A lethal dose of fentanyl is 2 milligrams. So when I'm telling you that these people, if you're carrying a gram of fentanyl, you know it's a gram of fentanyl. And that's not a gram that's for personal use. That's not something an addict would have. That's not something a user would have. To have a gram of pure single component fentanyl, that's what a trafficker would have. So that's why that's why this punishment is there. We're not going after the users. We're not going after the addicts. We're going after the traffickers and the people that are bringing it in our community. And with that, Mr. Chairman, I'd ask for a favorable passage.
Do we have any questions? Representative England.
You know, it wouldn't be right if we didn't start off the session with an argument.
Let's do it.
No, actually, no, I want to take advantage of this very limited opportunity that I have to say that we agree.
Y'all have that on camera, right?
Yeah. And, you know, concerning fentanyl and its derivatives and how dangerous the drug itself is, I think we're all trying to be as careful as possible to make sure that this addresses the specific community that or the specific people that we're trying to get at. And, you know, and I think we can acknowledge that in the past, sometimes we have used sledgehammers on ants and have actually created legislation that has actually gotten users instead of the people that we're targeting. And I think with the way you approached this legislation and how you did it, and also, I mean, it's from where it started to where it is now, I think this is a good bill to accomplish the objective. And also, we also want to focus on treatment, right? I mean, I think that's the point when we're talking about somebody who's addicted to drugs, who needs help, right? But as you pointed out, this isn't that. Mm-hmm. This isn't those folks. And I know we're also talking about prison space and so forth and using the resources that we have effectively. But there are some people, especially those who carry this, who are intentionally using it to put in other drugs that just need to be incarcerated. They need to be removed from the game altogether. And I think this accomplishes that. So it's a good bill, and I support it.
Chairman Hill is not going to know how to respond to that.
I don't either. I feel like I'm having an out-of-body experience right now. But
Thank you, Representative England. Thank you.
I hope this spirit of camaraderie and goodwill continues on throughout the day.
Representative Faulkner.
I can barely speak with what I've just witnessed by Representative England, and so I would like to move to give this bill a favorable report and have him second it.
Gladly. Second.
We got a motion to give the bill a favorable report. All in favor say aye.
Aye.
All opposed? Bill gets a favorable report. And we're going to take out of order HB 76, and I think it does have an amendment by Representative Simpson.
Yes.
Can you explain that bill, please?
Absolutely. This bill came out of a quadruple homicide in Daphne. What happened was an individual got into an argument with his grandparents. He had lived with them. He went to their home and tried to kick in the door, caused some property damage. The grandparents called the police. He was arrested. The only charge that they could charge him with was criminal mischief because he damaged the property or the door. He was arrested. There's no hold. There's no contact. There's no restraining order. He bonded out immediately, went back to that home, killed his two grandparents and two other individuals that were in the home as well. What came to me that day, well, I've talked to prosecutors that were involved in the case. I've talked with the law enforcement that were involved in the case. There was nothing that they could do. There was they can't put the hold or no contact or anything without domestic violence. Unfortunately, we live in a situation now in a society where so many grandparents are now the primary caregivers of the children. And there are protections in the domestic violence laws for parents, for step-parents, for spouses, child, stepchild, or any person who the defendant has a child in common, a present household member, or who they had a dating relationship. What this bill would do, and the intent of this bill, was to add grandparents to that relationship. Now, there is an amendment that was created from the District Attorneys Association, and on the language of the bill, we wanted to include grandparents into domestic violence as qualifying under domestic violence. The original bill did not have them in place with the domestic violence strangulation, which it should be. We want to have just a uniform domestic violence all through. Also, we're adding step grandparents, and we felt that it was important to add children or grandchildren and step grandchildren, because if the perpetrator in this case was a grandfather or grandmother acting domestic violence on a child, we wanted to have those enhancements as well, that we could pursue that charge under those. So that's the amendment. The bill itself is just literally, it's one word where it adds grandparent to domestic violence. The amendment comes through where it just adds grandparent, step grandparent, grandchild, and step grandchild to make it uniform domestic violence laws throughout the statute.
Do we have any questions on the amendment? If not, all in favor of giving the amendment a favorable Do we have a motion? Do you have a second? Okay. All in favor of the amendment, say aye.
Aye.
Opposed? Now, do we have any questions on the bill itself with it as amended?
Mr. Chairman, this, what we have in front of us already has the amendment?
The amendment should be included in your packet.
Oh. Thank you.
Do we have a motion to give the bill a favorable report as amended? Secretary Stringer? Okay. Do I have a second? Ms. Robbins, Representative Robbins, all in favor of giving the bill a favorable report as amended, say aye.
Aye.
All opposed? The ayes have it.
Thank you, Mr. Chair and members of the committee.
Okay. We have HB 82 by Representative Pringle.
Thank you, Mr. Chairman, ladies and gentlemen of the committee. This is a bill that this committee has passed out at least twice, if not three times. It's identical. For the people that are new to the committee, a friend of mine's son got addicted to oxycodone and after surgery, and his family literally mortgaged their house and sent him to rehab and got him clean. His drug dealer would start hanging out in front of the narcotyne meetings he was going to and trying to get him to take drugs. And it was so bad, he kept calling the kid. He actually changed his phone number. The drug dealer went to his parents' house and knocked on the door and told his mother and said, "Listen, I'm trying to buy this piece of real estate from your son. He showed me about 8 months ago. I've got the money, but I can't get him on the phone." And the mother, thinking it was a real estate deal, gave the drug dealer his new cell phone. And he started calling my friend's child and wore him down and sold him a oxycodone laced with fentanyl, and it killed him. The only thing they could charge that man with was trafficking drugs. What this bill says is if you sell a controlled substance that causes somebody's death, illegally sell a controlled substance that causes somebody's death, we can charge you with manslaughter. And you've already passed it 3 times, I think, out of this committee. It died in the Senate on the last day at the last minute, so I couldn't get it through last year.
Do we have any questions about the bill? Do I have a motion to give the bill a favorable report? Representative Simpson, do I have a second? Representative Faulkner. All in favor, give the bill a favorable report, say aye. Opposed? The ayes have it. The bill gets a favorable report.
Thank y'all so much.
HB 34, Representative Estes. Oh, 20, I'm sorry. HB 28, Representative England. Representative England, didn't mean to slight you there. I counted 3 and you were
Trying to be nice today, man.
Yeah, you're doing good.
Trying to be, you know.
Would you explain your bill, HB 28?
HB 28 was so as it stands right now, there are basically 3 subset of people that can carry a pistol concealed on school grounds. Someone who's been appointed to do so by the school board, which is generally an SRO, law enforcement, and according to the law, anyone who doesn't have the intent to do bodily harm has a permit and doesn't have the intent to do bodily harm on a school grounds. And what this bill would do would remove the exemption, and the only people that can carry concealed on school grounds are SROs, people who are appointed by a school board, and law enforcement. And that's it.
Do we have questions about the bill? Representative Stringer.
Just had a quick question. Like, how would this affect someone picking up their kid from a school line or maybe attending a sporting event where they have a weapon in the vehicle?
in the trunk, just like it was prior to. If this law goes into effect, that's what you'd have to do.
Okay, thank you.
Do we have Representative Sandridge?
Yeah, let me ask a question about that. Okay. I believe when we passed this, and this specific language was in there, was to address, I think, what Representative Stringer was mentioning. I mean, you have people that come to school that obviously carry their firearms in their vehicles, you know, just as a matter of personal protection.
Mhm.
And they have a permit based on that law. And so I think that's what that exception was really intended for, because you already have things in place on school building that would prohibit that anyway, correct?
No. School policy does, but that's for students. In order to, so someone carries a pistol or a firearm on school grounds, it's technically not illegal. So before, if you approach someone with an issue with a firearm on school grounds, you can't take the pistol, you can't do anything to subdue them. What you'd have to do is get them trespassed and send them off. A lot of people believe that, you know, mistakenly that federal law controls on school grounds, but it doesn't. We passed laws that preempt federal law on school grounds. So we have, like I said, when you get a permit, as long as you don't have any intent to do bodily harm, you can carry on campus. And for me, just schools need to be treated like courthouses, for example, because you can't have a concealed pistol on courthouse grounds. And it's always never made sense to me that we identify particular locations where we don't want you to be able to carry concealed at all, but where our kids are, it's okay. And also, there are places in the state of Alabama where you can get a pistol permit when you're 18. So that technically means that an 18-year-old or a 19-year-old with a pistol permit can carry concealed on school grounds. So, for whatever reason, to be honest with you, as long as you're not a student at the school. So essentially, what I'm trying to do is, since the state of Alabama has recognized that there are certain locations where it's not a good idea to have a concealed firearm, just want to add school to those.
So there's not an exception in the federal law, you're saying, for the school building?
No. And again, that's one of those things that people believe, but it's not exactly true. So with regard to—
That was my belief that it is.
Well, so because I'll read it to you. With regard to an issue of a pistol permit, the Gun Free Safety Act allows an individual to possess a firearm when the individual is licensed to do so by the state in which the school zone is located, and the state's firearm permitting requirements require the permit issuing authority to verify that any individual issued a license is qualified by federal law to receive the license. That's our permit. So federal law doesn't control on school grounds because we have preempted them there by passing our own laws.
Okay, but your bill here is for all property of the school, not just the building, right?
School. I think we follow the school zone includes the grounds of a school, public or private, in the area within 1,000 feet of the school grounds.
So it would basically be the whole campus, right?
Depending on how big it is, yeah.
Okay. Thank you.
Representative Simpson.
Under this bill, and under current law without this bill, if an 18-year-old is on campus with a weapon, somebody on campus, it's tough to prove that they have intent to harm someone until after they've actually harmed someone.
That's when we figure it out after they've done something.
So let's just continue this hypothetical to be 18-year-old on campus, gun either out or holstered, either one, and they're just walking around on campus with a gun. Is there anything an officer can do to that 18-year-old?
Trespassing.
No matter how many students are nearby, no matter how many kids are close by, no matter where
As
they,
long as that 18-year-old's not a student at the school, trespass them. Which means that in order to neutralize that threat, it's just like you and your private property, for example. Without notice of a trespass beforehand, you have to first identify that person, trespass them, and then tell them to leave. The only time you could arrest that individual for trespass is if they're first trespassed. So then they can come back, and that's when that's when they become arrestable, although I do think you have to do that in the presence of law enforcement anyway. So it makes it very difficult for somebody who's in charge of that property to neutralize a threat, because they've got to contact that person multiple times before they could be arrested. So again, and like you said, I think you've identified it perfectly. We oftentimes don't know that a person is a threat or has intent to cause harm until after it's done. So for me, and that's why I introduced legislation, in order to sort of eliminate that problem, limit concealed possession on campuses to just law enforcement and SROs.
Representative Faulkner.
Don't we have a alcohol law that for any school and on school property that you cannot take alcohol on school property?
I'm not aware of that.
Anybody help me out here? I thought you could not take, any alcohol on school property. Maybe it's just a city deal, but the schools I represent, it's my understanding you cannot have alcohol on the premises, and that's, if it seems to me, if we're not going to allow you to carry alcohol on a school property, I don't know why we'd let you, somebody that's doesn't, because you've got a lot of exceptions in here too, that cover things for valid reasons.
Yeah.
But I'm not sure why we would just we wouldn't allow alcohol, but we'll allow a loaded firearm. But perhaps that's a city ordinance, Chris, if you're not familiar with it. Nobody else is either.
I don't want to speculate, but
yeah.
Representative Bedsoe.
Yes, sir. Thank you. So Representative England, I think it's fair to say that, I think everyone here, the notion of keeping our kids safe is something, and that's a very real topic in our world today. So it's a tough and complex topic to dig into, as far as when we're trying to balance out that element of safety for our children, and also I think that the Second Amendment rights of our citizens. And so knowing that every school campus is set up a little bit different, I have a couple in my immediate area that just come to mind that something like this would give me a little bit of pause, because so some campuses are set up that once you drive onto that campus, you are exclusively there for the purpose of visiting the school grounds. There is a one-way in and maybe a second exit out, but you are going to that school property. One specific school in my area, and I can think of another, has designed this parkway in which the citizens of our city are able to use the parkway that traverses through the school property, but it's a means to get from one area to the other. Mm-hmm. So I just think of it in terms of the wording in which that we're dealing with in the bill, and that perhaps there's a citizen innocently driving from point A to point B using the parkway that's open for the citizens that has a concealed weapon. There may be even a permit holder with no intent to stop there in the school grounds, but simply using the parkway. So it does raise a little concern with me, knowing that if I'm traversing through there and I'm not a law enforcement officer and happen to get stopped on a traffic stop, mm-hmm. would I then be in violation of this law simply because I was passing through? And so I think the wording of this and the thought of how we deal with this individually or corporately to all school properties is something that we have to give some thought of. And so that's just my 2 cents on it. And I feel strange giving you advice because you're so good with words. And I'm thinking of a specific scenario that's literally in my backyard. And so I'm just got a little bit of concern there if I'm just communicating, being honest with you about that.
No, that's fair. It is. And, ultimately, completely open to discussing if there's a better way to define what we're talking about. But again, just the overall concern is that when we talk about school grounds, obviously it's outside, it's inside, it's somebody who's carrying a pistol concealed. And, you know, in order to neutralize threats on campus, when somebody who can legally possess, it becomes more and more difficult to assess that threat and then neutralize it because you've got more barriers to go through. Right. Whereas if somebody is possessing a gun in a courthouse, it doesn't really matter what the mind state is. You immediately see it, you seize it, and they're arrested. So again, and for me, if Alabama as a state recognizes that there are places that we should not have firearms at all, I don't know why schools aren't considered part of that list. So if as this process works, as it normally does, if there's any ideas you have, like you want to kind of massage the definitions a little bit and figure out like, well, because we don't want to say that anybody that doesn't have ill intent can carry a pistol as long as you got a permit. You know, that could be anybody. And again, from law enforcement, you oftentimes don't find out who the bad guys are until it's too late.
Right.
So, and again, this to me, prohibiting possession, concealed possession, it cuts down the response time law enforcement has, because if you got a pistol concealed, I can go ahead, neutralize that threat and get you off of campus. I don't have to ask you politely. Yeah. I don't have to make any assumptions. Just give me the gun and we'll figure this out. And, you know, being that we've got a lot of issues, and locally in my county, we had a 17-year-old with a gun at school. It just makes it easier for us to keep our kids safe if we can limit who possesses them. But at the same time, I do understand that those who are just traveling through yes, sir, may have an issue. So again, it's definitely worth a conversation for sure.
Thank you.
Representative England, a couple of the concerns that I have deal with the fact that you have all these folks that are in line to pick up their children. Mm-hmm. And by them driving through the campus to pick up their children, they're actually committing a Class C felony driving through. That's
they're not committing a Class C felony. Again, the mere possession, first and foremost, if you're not doing anything you're not supposed to do, obviously we don't have this problem. But at the same time, I have witnessed, and I got school board members and things that have witnessed issues that develop in that as you're dropping your kids off and pick them up, where you've got problems with principals, you got problems with teachers, other parents, or whatever, where our kids are around. Again, it's just, maybe it's just me, but I would prefer that we just limit possession on campus to individuals, law enforcement, and those who have been appointed by the school board to have those weapons for protection purposes. Now,
I'll say this, my second concern is in Alabama, we have what you call school indemnity property. We have 16 section property that's owned by the various boards of education. In Walker County, there's 8,000 acres of land that's owned by other boards of education in Walker County. And because of the definition of that's out here, I'm concerned that if you just go on that property, then you potentially could be committing a Class C felony. And for example, around the I-13 interchange, there's about 350 acres that's owned by the Franklin County Board of Education that is inside Walker County. Well, if you walk on that property, somebody goes on that property, say for hunting for some reason, then they could be charged with a felony. That's the concerns I have. I don't think the definition has been narrowed down enough on what's school property at this point. Representative Pettis.
I guess goes to my concerns. I'm retired law enforcement. As long as I qualify, I can take a gun anywhere in the United States, except in a school in Alabama.
That's not true.
I'm not a law enforcement. I'm retired.
I
don't fall under the law enforcement.
Specifically, there's a code section, it's in Title 16, that allows for retired officers who are appointed as SROs and also those who are commissioned as law enforcement to carry on school grounds. It doesn't apply to law enforcement in the same way that it applies with somebody that doesn't have or doesn't have the intent at the moment when they're possessing it. So it's different.
But if I go through this, well, the way I read it, it says if you don't have a permit and you have to be a law enforcement or an SRO. I'm not law enforcement anymore, I'm retired. I have to go qualify to be able to carry it anywhere in the country. The state recognized me as carrying it, but I'm not considered a law enforcement officer. I'm retired, but I'm still not law enforcement. If I go up there to deliver a check that I do now, if I have my pistol on, I could be charged with this, the way I read it.
I'm not exactly, I don't think that's exactly accurate, but we can talk about it. I mean, because there's a specific code section that creates exceptions for retired law enforcement and our SROs too. Those that are also those that are appointed by the school board for those purposes. But it's a legitimate question, and we can figure that out.
Okay. Representative Faulkner.
Yeah, Representative England, I first want to say that I like what your intent is, and I agree with you that this exception based on intent is I don't think that's good. Because we do, as Representative Simpson said, we don't know intent. And so I don't like that language. I think this needs to be changed. But I would, based on the concerns I'm hearing from the other members, I would like to say let's put this bill in the criminal or civil subcommittee and work on tightening up the language to meet the concerns that have been expressed. Because I think, I certainly think there's a lot of us that like what you're trying to do here, but just want to make sure we don't have unintended consequences that has been referred to. So that would be my request as we put it in, not to die, but we put this into a subcommittee.
Before we get to that, I take that's going to be a motion.
Yes.
Before we get to that point, I'm going to recognize Representative Simpson.
I just wanted to bring to the attention of the chair that Representative Faulkner is the chair of the civil subcommittee, and I think that would be great.
Okay.
This does involve a criminal statute.
Well, we have a motion before us to send the bill to the criminal subcommittee. Do I have a second? Second. All in favor of sending the bill to criminal subcommittee, say aye. All opposed? The bill goes to the criminal subcommittee. Representative Jim Hill, Judge Hill, is entered the room, and
I was sincerely hopeful that y'all would be through by now. Had to take something up in another committee. I'm disappointed. I felt like I'd walk in here and have you adjourn, but apparently not so.
That's correct. And so I turned it over to Chairman Hill.
Okay. What's our next one, Brad? House Bill 34, Representative Estes. Come on up, please. That'll help me.
Thank you, Mr. Chairman and committee members. I'll go ahead and warn you, I've never spoken before this committee before, so I'm not near as eloquent as my colleague, Representative England, and how beautifully worded some of his comments typically are. And I don't deal with the Second Amendment on this bill, so maybe that'll simplify things for you as well. It was just drawn to my attention a few months back that I think we have a small loophole in some existing state code that I would like to see us close. I know most of you have had a chance to read the bill, so I'm not going to bore you with going through every nook and cranny of it. Currently, as you know, it is a felony to discharge a firearm either into an occupied or unoccupied school bus or an occupied or unoccupied school building. There are some municipal codes that address this, I've been told it by LSA, but we don't have anything at the state level that addresses the discharging of a firearm on school campus, period. You could discharge a firearm on school campus and it not meet the criteria that I mentioned earlier about an empty building or an empty school bus or a school bus filled with children or a school building filled with children. So that's what this would do, would bring that under that classification to where it would be a felony to discharge on campus.
All right, any questions? Yes, sir, Representative Wadsworth, please.
Representative Estes, one of the concerns I have is that it has basically the same same definition as that previous bill, unless I'm missing something. It just says school property. That could be 16 section property.
Yes,
It
sir.
could be school indemnity property, and it could be the school ground where, and I personally don't think the definition is tightened up enough to know what that would be. And,
Well, I would certainly be open to an amendment because I was listening in the previous bill as it was being addressed and thought that you might have the same question. So I'm certainly open and would accept that as a friendly amendment.
at the appropriate time, I'd move to send this to the criminal subcommittee also for the purpose of further defining the term school property.
Yes, sir.
All right, hang on. We're going to take a few more questions. Mr. England?
You're talking about shooting on a school property.
Discharging a firearm.
So like pulling the trigger and a shooting on school property. What difference would it make where that came from? I mean, I understand some of the debate about possession, but firing a pistol on school grounds, I'm struggling to figure out, what difference would it make where that came from?
Well,
shooting a gun, and I'm not talking about some official event or some sanctioned event on school grounds.
Those exemptions are, as you know, built in.
Yeah, they're already there.
Yes.
So what we're essentially implying is, like, if you're 2 feet away from, or if you're 1,500 feet away from a school grounds, right, and you shoot that gun into a car, that's a capital offense. So I'm trying to figure out why you would need a definition in this bill about what constitutes school grounds if you don't have any protected exemption that allows for you to fire that weapon. I'm trying to figure out, because I'm pretty sure if you're firing a weapon on school grounds, you're probably trying to do something. So I'm trying to figure out what difference would it make if it's 1,000 feet or if it's, or if we're defining it, because if you're shooting at somebody or you're shooting it for any reason, it's probably not going to be the best reason if you're near a school.
Let me make sure I understand your question. Are you asking, like, if you were on the street or property across the street from a school and you discharged a firearm? That's not what I'm talking about. Is actually you're standing on school property and you discharge a firearm. And you know, there's places where children are outside of a school bus or a building. They may be on the playground. And technically that doesn't meet current code that talks about an unoccupied school bus or an occupied school bus or the same for a building.
Yeah, I don't see where the definition of school zone matters when you're discharging a firearm around kids on school grounds. So, it's probably time I want to make a substitute motion to give the bill a favorable report.
Well, let me clarify, Representative, if I may. Working closely with Representative Wadsworth as we share a district up in Winston County, and I'm very familiar with the 16th section land that he made reference to, both in my bill and in discussion of your bill. A lot of that is just forested land, and you could technically be standing out there on a piece of property and shooting through 400 acres of property and not hit anything, and there's nobody there for you to potentially hit, as there would be if you're on school grounds. That's what we typically define as school property.
But those aren't school grounds for the purposes of the law we're talking about.
Exactly, you're correct.
Yes, those aren't the school. That's not for the purposes of possession or discharge.
I understand. Yes, you're correct. I understand what you're saying. Yes.
Again, like I said, I'd like to make a substitute motion that this bill be given a favorable report.
Okay, do I hear a second to the substitute motion? Second. Thank you. All right, all in favor of the substitute motion, say aye.
Aye.
Any opposed? Okay. I'm going to take it then, Representative England, that we just gave this bill a favorable report.
Yes, sir. And if you want to make another motion, I can do that.
I don't think it's necessary.
Thank you, Chairman. Thank you, body.
Appreciate it.
Yeah, go ahead.
Tell you what, my bill's next, so let me do it. It's House Bill 37.
Chairman Hill, will you explain HB 37?
Yes, sir, I will. Thank you. It goes in a lot of ways hand in hand with things that we've been talking about. It does deal with schools, but not only schools. It deals with any type of real or personal property. But included in there would be churches, mosques, synagogues, religious property, schools, private or public. Two things that this bill does. If you make a threat, and it in here, it's called a terrorist threat, in such a manner that it is communicated and it threatens harm, and it does so in an unequivocal manner, such that the building where you are threatening the harm must be vacated. And at that point in time, it is a felony offense, and it is a Class C felony. So that would be one element. The other element of this is a second-degree terrorist threat. A second-degree terrorist threat would be a Class A misdemeanor, meaning that the building would not have to be vacated, but that the threat was real and threatened violence or damage. However, the building, the school, the mosque, whatever, did not have to be vacated. So here's the way I envision these. For example, someone comes to a school while school is in session and says, I have a bomb or I have a gun, and they vacate that school. That triggers the felony response. Someone calls on a Saturday and says, Monday, I'm bringing a gun or a bomb. That would also trigger the same event, but it would become a misdemeanor because there would be no disruption of the school or of the church or of the event. So those are that's the bill. And I would ask that you give it a favor. I'll certainly answer any questions, but I'd ask for a favorable report.
Representative Simpson.
Chairman Hill, let me start by saying this is a much-needed bill. I've prosecuted these cases. I've had to comb through this code over and over again to go through this, and this is a much-needed bill. I do have two questions on the language, just for my understanding. On page 3, line 65, and line 67, 68, the phrase "under the circumstances," subsection C, under the circumstances, the threat and harm is credible and imminent. And on line 67, the statement, in fact, on its face, under the circumstances. What is that language there? I mean, I don't understand the under the circumstances language.
I would say under the circumstances would be, because obviously the circumstances that exist at the point in time of the threat. For example, the school is occupied. The church is occupied. The courtroom is occupied. And the threat is, I'm going to blow it up, or I have a gun and I'm going to start shooting. At that point, in those circumstances would be, and those circumstances were communicated, and at that point in time, that would be unequivocal, and it would be the threat, and it would have a tremendous potential for immediate harm or damage, and consequently, the school or the building, would have to be vacated, and that would trigger the felony part of this this bill. And you had another question. If I missed it, let me.
No, it was just concerning the language with that. My concern is it's vague as far as what, if you're trying to prove the elements of the offense, you have to prove under the circumstances. If I could see a defense attorney coming up and saying, well, what circumstances? The circumstances aren't described. They're not put out forward through here. So, I mean, that's my only issue, but your expertise in the courtroom, I will say, if you're satisfied with under the circumstances, then I will be satisfied with under the circumstances.
I am.
Go ahead. Representative Stringer.
Thank you, Mr. Chairman. I wanted to also say I think it's a good bill and a needed bill. Recently, I'd say 2 or 3 days ago, we had a similar situation happen in Mobile at a hospital. But in these situations, they're teaching lockdown procedures instead of evacuations, and they locked the facility down at a potential active shooter, and they were having the law enforcement community was having a difficult time getting the charge on the person. So I think we need to address that, and I think what you've got here is a good bill.
Well, it would be disruptive.
Yes, sir.
If you lock it down, that's disruptive of what's going on in that particular facility.
Yep.
Any other questions?
Not.
Representative Fowler,
Representative Wadsworth, Chairman Wadsworth, I'd like to move to give the bill a favorable report.
do we have a second?
Second.
All in favor of giving bill a favorable report, say aye. Aye. All opposed? Bill gets a favorable report.
Thank you, sir. Appreciate it.
Representative Chestnut.
One way out. Okay, HB4, Representative Chestnut, please go ahead.
Yes, may it please your honor. This bill is a bill that deals with, you have to excuse me, Judge Hill. I was hearkening back to the court days, so.
Appreciate it.
Yes, sir. This bill is a bill that seeks to ban microchipping of employees by employers within the state of Alabama. I think it's a pretty straightforward bill. We define microchip and the word voluntary here. So if an employee wants to voluntarily be microchipped, then they can choose to do so. But we're saying that you can't tie conditions of employment to first being microchipped. So if there are no questions, then I'd like to ask for a favorable report.
Good question.
We got, I know you and I have talked about an amendment. Do you have it there, Mr. Chestnut?
Oh, yes, sir. Yes, sir.
And I will tell you, let me just explain it if I could, and then you certainly can comment on it. On line 71, page 3, it would allow the Bureau of Pardons and Paroles to install a microchip in an inmate in the event that individual was released early, similar to what we do with a monitoring bracelet. So it would give an exception to the Bureau of Pardons and Paroles. And on page 69, line 69 on page 3, add the word and, A-N. I have no idea what that is. Yeah, I'm gonna be honest, I don't know what the one and would be, so. Yeah, the only amendment I'm gonna make is on 71, page 3, allowing the Board of Bureau of Pardons and Paroles to implant a monitoring device in an inmate if they deem that necessary. I don't even know what it means. I'm trying to figure it out.
Subsection C on line 60. What it would do is it would take this section, may not be considered prohibited. It just replace line 69, which is and would be an individual voluntary.
So, all right, so back to it, it would, on 69, line 69, section C, would strike the words, "This section may not be construed to prohibit." So it would allow an individual to voluntarily elect the implanting in microchip. Okay?
Yeah.
That would be the amendment that I would ask. Yes.
Okay, no problem with that amendment.
Okay. So I would move that we accept that amendment. Are there any questions about the amendment? Seeing none, all in favor to adopt the amendment, please say aye.
Aye.
Okay, thank you. Now, Mr. Chestnut, we are back to your bill as amended, please.
Okay, I think there's a question.
Questions?
Yeah, I'm not going to ask you about companies, but is there any industries that are microchipping employees in Alabama now?
Not that I'm aware of.
Okay.
Wisconsin, yes, but not Alabama.
Okay. What industries in Wisconsin?
There's a tech company that's doing it up there.
Okay. Thank you.
Yes, sir, Mr. England, please.
A question at the appropriate time. I'd like to move the bill as amended to give a favorable report.
Okay, there's a motion as amended.
I did have a question.
Yes, ma'am, please go ahead.
Just one quick question. I see here where it states that, the Board of Department of Corrections can microchip an inmate, and also once they're out for parole. But once they have finished their parole time, will that inmate be, will the microchip be taken out of that inmate once they've done their time and released from all responsibilities?
Yes, I'm sure that once once you complete your time, that's a different situation. You're not awarded. You're not, overseen by the state at that point.
I understand, but is that somewhere written for that to happen?
No, because this bill was actually created to deal with employers.
Mm-hmm.
So we didn't. It's not like necessarily a parole bill.
Okay.
So I can't really answer that question. Judge Hill, do you have a?
Feel sure that they would be taken out, just like a monitoring bracelet would be removed at the point in time that the individual was no longer to be monitored. The chip likewise would be done also.
Is there a policy for that? Oh, we don't have a policy for that yet.
To my knowledge, we do not have a policy. However, the parole board would not have any authorization to monitor an individual once that individual was off parole. Yes, sir.
I had a question. I want to piggyback on what Representative McClammy said. So, Prince, I should ask you this earlier, but I know what a microchip is, but what is a other permanent identification marker? So, what else is there out there where permanently identifying people?
That's put there just to kind of be more of a catch-all, like dealing with sort of like biometric data, things of that nature.
Okay, I got you. Would
like the movies when they're
So to get to Representative McClammy's point, I know there's no policy on. I know we had this as an amendment. Would you kind of be amenable to putting something in as like point 2A that the Bureau of Pardons and Paroles must institute a rule on some time limit on when a microchip must be removed if there is one? If they put a microchip in a parolee, just so that way it would take care of her point and we'd have a policy in place to code.
Okay, well, that wasn't my amendment, so you might need to ask Judge Hill if you want.
I don't mind that at all.
Okay.
I want us to monitor inmates when they're released. If the Board of Pardon and Parole comes up with a methodology by which they implant a chip as opposed to a monitoring bracelet, I want them to be allowed to do that. So no, I certainly don't mind them removing it at the point in time that the individual's off parole, because I don't think there'd be any reason to keep it on.
I guess.
Yeah, I don't believe there would be a legal ground to keep a monitor device on a person who has actually completed his time. I mean, do y'all know of any case where a person has done all of his time and he's somehow subjected to a suspension of certain liberties after he's completed his time? I mean, usually they're still on some form of supervised probation or something like that, which means they haven't completed their time, which is why I think a lot of times defendants will sometimes say, hey, just give me straight time instead of all of these different, probation parameters, because they know that when they finish their time, then they're complete. But no objection if that's worded, in the proper form.
Judge, are you working on this amendment there? That's what I thought you were doing, so thank you. Yes, sir, please.
Prince, I do have a question. Is this just being proactive, or do you see it being a threat for?
Yes, it's just being proactive and preemptive. Actually, Nevada has already taken this proactive measure. Arkansas has also passed a similar bill. So it's something that, from everything that I'm reading, we're probably about maybe 10 years away from this being a thing, but I just want to make sure we're out front.
I have a question.
So Representative Chestnut, so you're already taking a stance here on microchipping. What's your next step on addressing artificial intelligence, just taking over the world? Is that your next step here or what?
Well, actually, I do read a lot of on that and watch a lot of films, and there are some things that do concern me. If I see something that I will address this body again. So.
On time, I have a question.
Okay, sure.
I just want to bring this up because I saw it. On line 73, you have this listed as a Class D felony. You realize that Class D felonies, there are really no punishments that they can be. They're really just a slap on the wrist at the absolute most for all Class D felonies, and there's no punishment for anybody that violates this statute.
I mean, but it's still a felony. I don't think anybody wants a felony on their record.
I'm just killing time until he finishes the thing. Are you proposing that the corporation get the slap on the wrist, the Class D felony? Are you proposing the supervisor? Are you proposing who would be responsible for the Class D felony?
Yes, it would be the person who, the decision maker at the corporation.
Representative Chestnut, some of the members here will remember my reference I'm about to make, but is it true that you have an intent here to accept an amendment to name this act after yourself?
No, it'll be the Judiciary Committee Act.
Yeah, I think since the name's already taken, I think Representative England's right. We've got to add in the Representative Prince Chestnut Microchip Act. I think is what we'll have to do here. So, which has quite a ring to it. So, thank you.
David, how much time do you think you take?
She had to print it. Mr. Chairman, I make a motion that we move this over to the call of the chair.
All right, we're gonna move this over to the call of chairs. So we'll hold this for a minute. Representative England, how about HB 13?
All right, House Bill 13 attempts to amend legislation that we passed a couple of years ago that allowed municipalities adopt certain criminal offenses to give citations for. While that bill was going through the process, it was amended at the very last minute, and it was a particular section was added that reads, this section only applies to municipalities that do not employ a full-time municipal judge. Notwithstanding the foregoing, a municipality that employs a full-time municipal judge by local law enacted by the legislature may elect to apply this section. While that amendment was only designed to target specific offenses, it actually amended the entire code section. So that means that if your city employs a full-time municipal judge, then your city can no longer write citations for anything. So what my bill does, it eliminates that so cities can once again write citations for certain offenses. There is a technical amendment at the appropriate time. I will explain that. Okay, what it does, if you go to replace on lines 73 through 76 on page 3 with the following, it strikes the person is charged with a violation of carrying a pistol without a permit as provided under section 13A11-73. It renumbers it and just says J, the strikes person, individual is charged with a crime that. And the reason we're taking that out is because we no longer require a permit. So it's not a crime.
Okay, does everybody understand the amendment? And is there a motion to adopt that amendment?
Out of playing nice with each other today, I'll make a motion we adopt that amendment.
Thank you. Is there a second? Second. Okay, there's a motion and a second to adopt the amendment. Any questions on the amendment? All in favor say aye. Aye. Any opposed? Okay, thank you. Now, Representative England, I guess we're
on the bill as amended.
To you as amended, yes, sir.
If no further questions.
Make a motion to adopt.
Thank you, ma'am. Is there a second? Second. There's a motion and a second to adopt the bill as amended. Give it a favorable report. Any other questions about it at all? Seeing none, all in favor, please say aye. Aye. Any opposed? Okay, thank you.
Thank you.
Thank you. Representative England, you might as well stay up there if you will and do HB 16.
That's going to be simple. All right. Thank you, Mr. Chair. Those who know me know that one of my favorite pastimes is talking about pardons and parole. And I think that one thing that we can all agree on is that that process itself needs a little bit of work. I think we can agree on that the process needs some oversight. And what House Bill 16 does is essentially attempts to create that oversight. It creates an 8-member Criminal Justice Policy Development Council that will help create guidelines for the parole board. It will update the inmate classification system, adopt a validated risk and needs assessment for felony offenders, and provide quarterly reports to the legislature beginning in October of 2023. And the bill does not take away the board's independent decision-making authority. The board can continue, as it is doing now, ignoring guidelines. The board can continue, as it's doing now, making arbitrary decisions without considering the circumstances that the applicant has worked towards, put forth. It also can continue ignoring the fact that the Department of Corrections themselves have identified a number of people who are no longer a threat, to the point where they spend their days outside of the facility and only come back at night. Those folks are being routinely denied as well. So what this bill would do will be create that oversight, would create the ability to appeal and review those decisions, so we can begin to massage that process a little bit and make it just a little bit more effective. So with that, I'm willing to answer any questions you may have.
Okay. Any questions? Yes, sir. Go ahead, Mr. Pettis.
Appropriate time I ask for a roll call.
Okay. We'll do a roll call. Sure. Go ahead, Mr. Robbins.
I have a few questions.
Yes, sir.
Representing England. One, why did you set the number at 8 on the board as opposed to like an odd number, so in case there's a tie?
Oh, it's a great question. And if you want to amend it to offer additional members, take some off, I'm completely open to that. But I mean, there wasn't any general science behind it. It was just those particular individuals that we thought would be important to the process just ended up being 8. So.
Okay.
Yeah.
I mean, because I was just wondering, because whatever happens when you have an odd number, you got 4 and 4 and you don't get anything. But I didn't know, in looking over, you've got Senate Judy, House Judy, minority party in the Senate, minority party in the House, and LSA. I'm sure Representative Simpson would appreciate this, but have you thought about adding a prosecutor or the DA's Association or the Attorney General's office?
Sure.
Someone from that onto the board?
That would be, in my opinion, a friendly amendment. If you wanted to offer that, if you wanted to offer someone, actually Representative Bedsole brought up a point this morning when we were talking about your good time bill, about having somebody with experience managing a facility. I mean, I would be open to that as well. It's just, again, this is not the end all be all. If there's better ideas out there, bring them on.
Okay. And I had one other question, that on page 6, where it talks about the appeal process, and you say within 30 days with the board denying a prisoner parole, blah, 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 may appeal the decision. So is that the statute of limitations, how long a person has, or do we have, should we put into the code some sort of statute or a limitation on how long the party has to appeal this decision?
And honestly, I think we're kind of plowing new ground. So I think we would be, in essence, creating that. So I think the 30 days is just, something to make sure that the process is moving. So, I mean, again, it's one of those things, like if there's a better idea, I mean, if you think we need to create some sort of statute, then I'm more than willing to listen to that as well.
Okay. I was just thinking on if I'm that person that was denied parole, how long would I technically have to appeal the decision? Because at some point, would you have, a year, 2 years, or, relatively, because if you have a decision in a circuit court, there's a time frame on how long you have to appeal that decision. And with this, it just says you may within 30 days. So I kind of wondered if we wanted to set some sort of limit on how long a party has to appeal the decision.
Yeah, I mean, it makes sense. Right now, I think there is no time limit. So I think anything that we're creating would define the process. And I want to remind, it's not just an appeal from a denial. It's an appeal from if you're deviating from.
Right, from the guidance or for the recommendation based from the committee, right? So if they say do X and then the pardons and paroles does Y, then you get an appeal because they did Y instead of X.
Yeah.
So if you would be okay with it, I mean, I'll leave this up to you. If you said add another member, would you be more open to the DA's association or the AG's office putting an appointee on the
that sounds like a trap. Either way, it's fine. Adam, you know, if it's somebody from the AG's office or somebody from the District Attorney's Association or both, I mean, either way, it's fine with me. I'll be open to that amendment.
Okay. I mean, I had one prepared right before we walked in here to add the AGs.
That's fine.
Appointed, but then I was like, I'll let Representative England choose
that's
what
fine.
he wants. So
that's absolutely okay.
And so if at the proper time, I'd like to introduce an amendment to add an appointee from the Attorney General's office, and I'll give this to Brandy. I'm sorry, I just got it done.
I think this is the proper time. If we're going to amend this thing, let's do it as we move down. So the amendment is to add another member. That additional member would be appointed by the Attorney General. Is there a motion to do that? I guess, well, you making the motion, aren't you?
I'm making the motion.
Is there a second? Okay, there's a motion and a second. Any discussion on the amendment? All in favor of the amendment, please say aye. Aye. Any opposed? Okay, the bill is amended to add one individual appointed by the Attorney General.
Great, thank you. Any other questions?
Yes, sir. Mr. Starnes.
Representative England, this is my baby too. I was spent 25 years with pardons and parole, and I just want to say that it's a hoax that the parole board is not releasing folks. We have mandatory release, and they are being released left and right. Now, when the parole board has a packet or considers somebody on parole, that offender is the bottom of the bottom. So with that being said, I truly oppose this council, and I would like to move this forward as to kill this council, because I think it's
is that in the form of, is that a kill the council motion?
I'd like to make a motion to for this resolution to die.
Is that another kill the resolution motion? Would you allow me to respond to what you just said?
Yeah, yes, sir.
And I'm kind of confused because you said mandatory release, correct?
Right. It's just
so
another
people. So people are being released, right?
Yes, sir.
Mandatory release is short of parole, correct?
It is
two different things.
But it's just another form of parole.
It's not.
It is.
Because when we're talking about parole, what we're talking about is an applicant who becomes eligible for parole, who fills out an application that goes before a board that makes a decision. Our mandatory release, the one we just had, that went horribly, by the way. We're not talking about that, but that was based on a time certain. So once they reached a point, they became eligible for mandatory release, but they don't go before the parole board. Is that correct?
Correct, because they're automatically coming out.
So this bill doesn't have anything to do with the mandatory release component. It is two completely separate things, and I don't want to confuse those two things so people get the wrong impression about what we're trying to do here. So when you say people are being released all the time, sure, the mandatory release, that happens. But when we're talking about going to the parole board, the exact opposite happens, and the numbers are showing that. We're less than 10% of applicants who go before the parole board who are being released regardless of their risk assessment. We paid a lot of money years ago to make determinations as to who's a threat to the public and who's not. We paid a lot of money for that because we wanted at the time to use those risk assessments to make determinations as to who gets released or not. To that point, that law requires that the board actually create guidelines that they're going to have to give to the Legislative Council this year, because we had every intent of having guidelines created and the board following them. So it's to our surprise, after that legislation was passed in 2019, that in over 80% of the cases, they're ignoring their own recommendations from the guidelines that they're supposed to create for themselves. So no, a lot of people are not being released by parole. Mandatory release is a completely different thing, and it's almost disingenuous for you to try to conflate the two to create an impression that this board is actually working, and they're not.
And Mr. England, and I disagree with you, because what they have in front of them is the bottom of the bottom because of mandatory release. Now, those people would have been considered for parole before we had mandatory release, and the numbers would have went up. But I'm just saying, mandatory release has emptied the bottom, and there's just not many applicants out there on parole to select from.
That's, I mean, that is almost, I mean, that is like, I can't even come up with a word to describe how inaccurate that is. And you're also talking about the bottom of the bottom. Well, you're not talking about the bottom of the bottom. We're talking about the body itself, okay? We didn't have mandatory release to the degree that we had up until recently. Our parole rates have dropped under 10% since 2019, since we passed the law and appointed a new chair. So before 2019, we were over 50%. It's only until recently that we're down below 10%. It's not the same thing, and it's not fair to conflate the two. And also, let me just point out, just a few days ago, maybe a week ago or so, this meaningful process allowed for those folks to deny parole to somebody who had died. That should offend you, because that means they're not doing any sort of adequate review of the person that applied. They don't know if that person, I mean, to say they don't even know if that person is alive or dead, they certainly don't know if the applicant that came before them has completed any programs to better themselves. They don't know if that person who in the 20 years they've been incarcerated has actually improved and would be a benefit versus costing us a whole bunch of money. And to that end, they also don't know if, unless they're told that somebody who's over 70 years old, who's sick, infirmed, no longer a threat to society, and is probably going to die within the next 6 or 7 months, gets denied just so they can die in prison. It's not a meaningful process. It's just not. And to pretend like they're going through this review, they're taking these applications at face value and not treating everybody the same based upon the offense they committed 20 years ago is inaccurate and unfair. And also, I don't think we should come to the point where we're looking at legislation, right? And we're saying we recognize that there may be some issue there. Because again, a process that works doesn't deny parole to a person that's deceased. It doesn't happen.
Well, I'll say this on that. That would be the officer that did the investigation. I wouldn't put that on the parole board.
But I mean, if the parole board is asking rudimentary questions about, is this person alive or dead, we don't get to this point. But they don't, and I mean, it also brings another point that they don't even address the applicant, so they don't know anything about that person. They don't. They only hear from one side of the process, which is why it's not working.
I would disagree with that, because IPO officer goes to the prison, they interview that person with their personal social history and gives a report of their arrest record and also the details of the offense.
In less than 5 minutes and the person's not there.
I absolutely disagree with that, because they review their jackets and they do talk to them. I've done it myself.
I've been to it recently, and I've also talked to many families who've gone through this process. Trust me when I tell you, it's not exhaustive.
Well, now you're talking about the hearing. I'm talking about when the institutional parole officer goes to the prison, interviews the inmate, and makes that presentation, receives that application, and goes and makes his report.
With all due respect, I'm not talking about the officer that's doing the investigation. I'm talking about the decision from the parole board.
Right, but that helps the decision like a PSI does for a judge.
Yeah, and it's so exhaustive that a dead person got denied.
All I can say on that is that the officer didn't do his job. I don't know the details of that, but.
Right. But again, since 2019, we are at record lows on both pardons and paroles. And essentially, if we're going to analyze our entire prison population, right, and we have a board that's making determinations in regards to someone's threat to society, or threat to public safety, And meaning that process isn't meaningful to the point where people who are inside, who don't spend their days in the facility, they're actually out because the Department of Corrections, the people that are with them every day, have decided that they're no longer a threat. And that same person goes, and almost over 70% of those folks are being denied. Is the process working? And again, you and I both are concerned about public safety. But if we're not creating space within our prison system, we're holding more people that annoy us while more people that we're scared of go free. And if we have a choke point in our pardons and paroles, that means it trickles all the way down to the court system, where people who are on bond, who are dangerous, don't have, or are pushed away, pushed aside, or cases are continued because we just don't have space to hold them. And it starts, our choke point is at the pardons and parole point, where in 2019 up until now, our prison population has skyrocketed. So I don't know about you, last I heard is that we're at $1 billion on one prison. Don't know how much the second one's going to cost. We'll never get to the third, which is the women's facility. And all we're doing is making the problem worse by not addressing our problem in pardons and parole.
Yes, sir. Thank you.
Mr. Robbins.
I make a motion that we move this to the criminal subcommittee because I think there's some more work that could be done on this, and then we could maybe get it tightened up for a vote maybe after spring break.
I second that.
I'd like to talk about it for a minute before we go through there.
By all means.
Okay.
I think the problem that we have, the problem that I have with this is, Representative England, you're arguing about a parole board not doing their job. And that's your argument, that the board is not doing their job. So the answer to that is to create another board. And this other board is going to create these guidelines, and you can call them voluntary for whatever you want, but if they deviate from these guidelines, there's an automatic appeal process to the Court of Criminal Appeals, which is harder than any guideline of deviation on any sentencing thing that you have to go through. So you're creating this new level of government that will come through. You're creating a new bureaucracy to oversee the Board of Pardons and Paroles that will come up with these guidelines that if Board of Pardons and Paroles does not follow, there is an immediate appeal process to the Court of Criminal Appeals. I think we're growing government exponentially here. I do think that this is, if you don't like the people on the Board of Pardons and Paroles, you have avenues to either appeal to the governor or what we created for that board for the 2019 law that we changed. But to create this new committee that now has oversight of this, my concern is, okay, what happens if you don't like what this committee does? Are we going to create another committee to review what this committee does, to go have say-so over that committee? And we have this never-ending growth of government to, at the end of the day, we'll have 15 people as a bureaucracy deciding what we're going to do. And then if that committee doesn't like it, we're going to do something else.
Understood. The only way to get rid of a board member is impeachment. Secondly, generally speaking, when the legislature doesn't want to deal with something, we create a committee. We probably created committees to oversee problems that and situations that we've already got. I mean, hell, we just created a committee to deal with ARPA. That's what we do down here. When we want to avoid problems, we create committees. That's our approach. So the fact that we're talking about exponentially growing government, I mean, that's what we do here every day. And as a matter of fact, so many of our systems that we create break down that we are always here passing laws instead of dealing with the problem where it is we create another law to deal with the problem that we just created. That's what we do here. As a matter of fact, if we didn't, we'd probably be all unemployed.
Carter, you had a question or comment on the
Yeah, I'm going to kind of echo Representative Simpson. He said it very well, that are my problems and concerns with the bill. I know our AG has spoken formally in opposition to this bill as well. But Representative England, I have the same issues with the bill as Representative Simpson.
standards?
Yes, I would kind of like on the same lines. My concern would be just by reading the bill is if they're denied, it looks like to me, basically, I would say all of them would appeal to this. Why wouldn't they? They would appeal to this next level. Well, when in my background, I've dealt with a lot of victims of crime and what they've been through. And, you know, they've had to do this at court over extended period of times. Then they come up for parole and they relive it. They relive that situation, and then they're going to basically, I think, pretty much automatically appeal to this board. And then whatever happens in that board, they may be denied there too. And then it goes to Board of Criminal Appeals. And so the victim relives it yet another time.
I just want to correct that.
So
You're not appealing to the board. You would be appealing to the court of, I don't think it matters at this point.
Okay.
I just want to reiterate, you know, we're 50% over capacity. And, you know, either we're going to do it or somebody else is going to do it for us.
Okay. Gentlemen, go ahead, please.
Representative England, as I read the bill will dissolve itself 2 years from now, correct?
Yeah, it's sunset, yes, sir.
Unless it's extended by the legislature, correct?
Yes, sir.
So removing a committee potentially, correct?
Yes.
So therefore not growing government in this particular instance, correct?
Yes.
No further questions.
Mr. England, you talk about corrections, picking people that they think the risk assessment. I'm going to give you an example that happened on my Nick Reisner bill. Subject went up for parole. He was denied. Department of Corrections said, oh, we're going to give you good time back. With the click of a signature, he's out. He kills 2 people.
Yeah.
Looks like Department of Parole is doing a better job than corrections. And also, you talk about corrections letting people out. If you look at these who, every day all the time there's prisoners that are escaping that are out on these work releases or different things. It's not hardly a week goes by, especially in North Alabama. Decatur's notorious for escapees. So I know the Department of Corrections is supposed to be picking, but looks like they're not doing a great job of a lot of them they picking also. So I think Department of Parole is doing a better job than corrections in what I'm seeing.
I'm going to be honest with you. I've never heard anybody saying that the Department of Corrections is doing a better job than anybody.
Well,
I also haven't heard the opposite. And so if it's a race between the pardons and parole and the Department of Corrections, ain't nobody going to win that one. It's a tie.
Yes.
And also, I just want to point out also with the good time stuff. Again, we've talked about this, and I understand where you're coming from. But I want to make sure we understand that it wasn't necessarily the good time law that was the problem. It was the employees who were supposed to interpret who's supposed to get good time and who wasn't. Because if they had actually followed the law that was as is, they wouldn't have been on good time anyway. They wouldn't have been out. So, I mean, those situations are so unfortunate because I think we're blaming the law for just outright incompetence.
What happened on the prisoner, the good time, he got all of his good time taken away from him. But a warden in a struck for pen can give it back the way it is now. And that's what happened. He got out and he killed 2 people, which one of them was a police officer.
But again, it wasn't necessarily the good time, it was the fact that he got it back.
Yes.
And the calculations, you shouldn't have had it. Shouldn't have had it. So again, I think we probably beat this horse back alive. But I do want to say though, I do appreciate the discussion. Honestly, I do. And I do, because it's these discussions that help us recognize that there may be an issue, there may be a problem. And there is a problem. And ultimately, like I said before, if we don't do it as a legislature, we're edging dangerously closely to someone putting our prison system in a receivership and forcing us to do the job that we're refusing to do right now. And my approach may not be the best one. I'm not saying that I'm the smartest guy here, but at the same time, I would love for all of us to kind of try to come up with some solutions here because our prison system is growing, our population is growing, our public is not safer as a result of it, and we're just not doing anything to stop it. So, thank you.
All right, hang on, Mr. Allen. What I think we've got right now, ladies and gentlemen, is a motion to send this bill to the criminal subcommittee. And all in favor of that, please say aye.
Aye.
Any opposed? Okay, that's what we'll be doing. Thank you, Mr. England.
Can you put it in there with my gun bill so I only make one trip?
Yes, sir. We can do the England Criminal Subcommittee time.
I have a feeling that's gonna be my life.
It could be. Next one is HB 39. I've had some discussion with people about that. I am going to carry that over. So that brings us down to Representative Alban. And by the way, ladies and gentlemen, this really is her very first foray into this committee, and I would ask that our committee members remember that and treat her kindly, because this is a good bill. What that? No, we'll carry it over. Carry over 39.
Thank you for that, Judge. I do appreciate that very much. It is my pleasure today to bring to you the Colby Act. And the Colby Act is named for Colby Spangler, and Colby is here with us. Colby, would you please stand and let us see you? Colby is here with his mother, Kim, and let's give them a round of applause. Colby and his mom came to see me this past fall in Tuscaloosa at my law office to talk to me about this bill, which is one of several across the country that are going on. I think 13 states have already adopted some form of this bill, and many more are considering it. It's also approved and recommended by the American Bar Association. It's really another tool in the toolbox, if you will, for people like Colby, who will be able to use what this will provide for us. And what that is supportive decision-making. The goal is to have a team of supporters for somebody like Colby to be able to nominate to be on his team, and they will help him to make decisions and communicate decisions with others so that he can live independently. And it might be easier for me to tell you what it's not. So currently we have guardianships and conservatorships for people who need assistance in decision-making, or frankly, who can't make decisions on their own. So they go to probate court, and the probate judge will appoint a guardian and or a conservator to act on their behalf. In order to do that, the court has to determine that that person who needs the assistance is unable to act on their own. So they basically give up all of their rights to make decisions for themselves, and a court-appointed guardian or conservator will make those decisions for them. That's not what this is. We also have powers of attorney, which is outside the purview of the court system, that I can execute, you can execute to name somebody to act on your behalf. You basically are handing them the power to act on your behalf, and there's no limitations on that. They can do what you want them to do. They can do something totally opposite of what you want them to do. And that, again, is not what we're talking about here, and we're not changing any of that, okay? All those things will still exist. What we're doing is adding a supportive decision-making agreement to allow people like Colby to bring people onto his team and to enter into an agreement to then be able to communicate with third parties his wishes. They are to abide by his wishes and to carry out what he wants to do. We do have 2 amendments that have been brought forth to this bill, and at the appropriate time, I'm happy to discuss those.
How about this, man? Let's go ahead and discuss Amendment 1, which I think is nothing but a form wherein someone would fill out to do this. Is that correct?
That's correct. We felt that it was hopefully will be helpful to have a form that is recognizable by third parties, so they'll recognize what the supportive decision-making agreement is. This was taken from one of several that are out there and used in other states. So that's what Amendment 1 is.
Go ahead, Mr. Chairman. Motion to adopt the amendment.
Second.
All right. There's a motion and a second to adopt Amendment 1, which is a form where someone would fill out in order to facilitate this act. Okay, is there any discussion on that? All in favor, say aye.
Aye.
Okay, let's talk about Amendment 2.
Amendment 2 just came to me from someone reviewing the bill and suggested that we add this language that no one can require an adult to execute a supported decision-making agreement for any purpose. Just
Okay. All right.
to make that clear.
To adopt the amendment.
All right,
Second.
motion and there's a second. Any discussion on Amendment 2? Okay, all in favor, say aye.
Aye.
Okay, so
Have a
Ms. Almond, we're back to you on the bill as amended, and Mr. England?
motion to give the bill a favorable
Second.
report as amended.
I want to ask a question.
Okay, wait a minute. Okay, we got a motion and a second to give the bill favorable as amended, but yes, Mr. Wadsworth, go
Just
ahead.
wanted to find out, there's no bond, no inventory, no accounting or anything.
No.
Is it more similar to a power of attorney?
It is similar to a power of attorney. The difference is that the person that enters into this agreement with you has to do what you want them to do. That's the whole goal.
Do they have to be competent in order to sign this?
Yes.
And does it have to be approved by a probate judge?
No.
Okay, it's just strictly what they fill out.
Similar in process to a power of attorney in terms of that's something you do outside the purview of the court.
Is it more of a limited power of attorney, so to speak?
Well, it's different from a power of attorney because in a power of attorney, once I have that power as agent, I can go and act on your behalf, and it can be in something you want me to do or something you don't want me to do.
Okay, so this is whatever they want you to do.
Correct.
Okay, thank you.
Mr. Rollins, do you have a question?
I was going to say, Representative Wadsworth kind of asked it. I was going to ask about if you had thought about having any kind of bond or, because I know with conservatorships, you have to have a bond. And so I saw in here you're acting as a fiduciary. So I just wondered if you'd thought about, or if any of the other states have added it.
To my knowledge, the other states do not do that, and we really were trying to mimic what's worked in other places at this point.
Okay, I have no questions.
There's a motion then, and a second to give this bill a favorable report as amended. All in favor, say aye.
Aye.
Any opposed? Thank you, ma'am.
Thank you, Chairman. Thank you, committee.
Representative Chestnut, can we go back to HB 4?
I have a motion.
Yes, sir.
Motion to give the bill as amended a favorable report.
Which one?
HB, no, oh, well, I'll make a motion to adopt that amendment.
Motion is to adopt amendment number 2, which would be to have the Board of Pardons and Parole promulgate rules and policies concerning microchip in insertion, maintenance, and removal.
Yes.
Okay.
Make a motion.
Is there a second to that? Second. Thank you. Any discussion? Okay, all in favor of this, I think this is Amendment 2, say aye.
Aye.
And Mr. Chestnut, then, where are you? Right here. All right, Mr. Chestnut, since you're the sponsor of the bill, I'm going to assume that you make a motion to give the bill a favorable report as amended twice. Is that correct? Correct. Okay, is there a second to that?
Second.
Thank you. Any discussion? Okay, all in favor of this bill getting a favorable report as amended twice, please say aye.
Aye.
Any opposed? Thank you, ladies and gentlemen. That's it. We appreciate it. We'll see y'all next week.